So we'll look at the list of dates?
Yes, Melissa. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President of Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill. This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to Your Lordships, now there's no question of majority, minority, 1/3, 2/3, not relevant, if there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection.